Right, good afternoon everybody, and welcome to this Court of Protection Masterclass, all about hoarding and the orders that can be sought in respect of hoarding, both in the Court of Protection and in respect of property orders that can be obtained. You're going to be hearing this afternoon from two members of Chambers, Peggy and India. My name is Lee Parkhill. I'm another member of the Cornerstone Court of Protection team, and I'm going to be chairing this session. Our COP team at Cornerstone undertakes a wide range of Court of Protection work, both health and welfare and property and affairs, and a number of our members are also experts in property law and housing, which is particularly useful for the topic we're going to be talking about today. As I say, we'll be hearing from Peggy, who is ranked in the directories as a leading practitioner in Court of Protection work and is a very experienced Court of Protection lawyer, and also from India. You may have seen in earlier material advertising the session, it was going to be our colleague Verity who would be delivering this session with Peggy, but in fact it's India, I'm delighted to say, who is joining us. India's an experienced Court of Protection barrister ranked as a rising star in the Legal 500 for Court of Protection work. We'll hear first from India, providing an overview of hoarding and the difficulties it gives rise to and some practical considerations to think about, and then hear from Peggy, who's going to look at the complexity of hoarding cases and the orders that can be obtained in respect of the hoarding person's tenancy to tackle the issue. We'll then have some time at the end for question and answers. Please feel free to ask questions. You can either do that in person or use the chat function that should be at the bottom of your screen. You can ask questions as we go or save them to the end. We'll address the questions at the end, but you're welcome to put them in the chat function as we go along. This session is being recorded, and the recording of the session will be sent to you all by email shortly after the session concludes. So that's all I wanted to say by way of introduction, so I'll hand over now to India to get us started on the overview of the hoarding issue and practical considerations.
Many thanks, Lee, and good afternoon all. As Lee has just outlined, I will be discussing an overview of hoarding and practical considerations, and then Peggy will take over and talk about the hoarding complexities. In terms of the overview of hoarding, firstly, I thought it would be very helpful just to set out, as I'm sure is very well known, but a few examples of overlapping issues that the COP can have with housing proceedings. And particularly, of course, in the County Court for housing related matters, because when making a COP application, it is always worth remembering that if you are dealing with a particular issue where, for example, P is known to be a hoarder or P is known to be being cuckooed, then firstly, possession proceedings may already be ongoing, they may already have been issued, or they're imminently about to be issued. And that decision will impact, firstly, on a number of issues in terms of the COP, for example, residents, what are the available options, but also in terms of case management. So it's always worth making inquiries to confirm the status of possession proceedings with the relevant department within the local authority or housing association. Because if possession proceedings are about to be issued, consideration might be given to issuing both the COP and the housing applications to be listed together. So in terms of the COP issues, of course, the usual domains of residence and care is very likely to be applicable in the majority of cases. But you also want to be considering, before you issue an application, well, are there other issues that are likely to be at the forefront of consideration? So, for example, if P is being cuckooed, and there is concern about individuals that P is known to associate with, questions should be sought right before the application is issued about are contact orders likely to be sought? If so, a contact MCA should be issued with the application, as well as the usual MCAs on care and residence. Equally, if P is being cuckooed and the local authority are making an urgent application to move P on an interim basis, well, you don't want to have any delays to be caused at the first hearing by not having all of the relevant evidence and the relevant MCAs. So if, as I say, you're making an application for an urgent move, you want to be filing with your initial application an MCA in relation to P's capacity to enter into a tenancy agreement and to surrender a tenancy agreement if applicable, as well as, of course, the residents and care. Again, for hoarding cases, if P's hoarding is likely to cause a significant risk to P and others, whilst throughout the duration of the proceedings, you're very likely to obtain further evidence about P's hoarding disorder, you might want to give consideration to, at an early stage, filing a COP3 in relation to P's capacity to manage their items and belongings, because an interim order might be sought in terms of permitting staff, for example, to enter a room to manage the risks and to manage the belongings. So, as I've already touched on, always consider what domains you want the court to make, not only on an interim basis, but also on in terms of final declarations. And as I'm sure this is well known, but this slide sets out a few key authorities for some domains to consider, as I've touched on in my earlier slide. Of course, each capacity is decision specific, and I would always advise, as I'm sure again is well known, that MCAs should be completed per domain on separate assessments. Sometimes the risk, if you complete a COP3 that deals both with care and residents, there is a risk that the assessor will conflate the domains, and that can cause issues with the other side seeking to challenge that capacity evidence. Again, in terms of the basic practicalities to always consider and advise on, the assessor should be specifying the relevant information that will be asked, that has been asked, sorry, of P in the COP3s or the MCA forms. And in terms of each domain, for example, whilst there is an overlap, as I'm sure is well known, in terms of residents, care and contact, the leading authority for both all three of the domains, but particularly for residents and care, is LBX. And in that case, the court set out the relevant information, this is Justice Tice, for residents at paragraph 43, paragraph 45 is contact, and paragraph 48 is care. And in terms of residents, this relevant information includes, of course, if applicable, what the two options or options for available accommodation are, the differences between living somewhere and visiting, the activities P would be able to do, who P would be living with, what sort of care P would receive. And then in terms of care and support, again, as I'm sure is known, what areas P needs support with, what sort of support P needs, who will be providing them with support, contact, similarly, details such as whom the contact will be with, the nature of the relationships between P and the contact, are there any risks, positive or negative aspects about having contact with a particular person. And then in terms of managing items, belongings, but also tenancy agreements. Firstly, with tenancy agreements, again, as I've set out, it's domain specific. So the first question that needs to be sought is the issue or the agreement that the court is invited to sign on P's behalf, is it definitely a tenancy agreement, and is it instead a license agreement? So, for example, a tenancy agreement is a contract between the adult and the landlord, which creates certain legal rights, some of which are created by the contract itself. And the key features of a tenancy agreement as compared to a license agreement are that it relates to the grant of exclusive possession of premises for a period of time and at a rent, and it is the exclusive possession. And that, of course, is also relevant to when you're seeking orders for managing items and belongings, because sometimes the sometimes the COP will need to make an order to provide permission for a staff member to enter into P's property for the purpose of their items and belongings. But in terms of going back to the tenancy agreement, a leading case on this is London Borough and Islington. And again, when I say that a separate COP3 should be done per domain, this equally applies to tenancy agreements. I sometimes see cases which assess P's capacity to manage a tenancy agreement, and this can cause issues when you're seeking an order to sign a tenancy agreement to enter on P's behalf, or equally to terminate. So one MCA should be done on entering, which is paragraph 101 of Islington, sets out the relevant information, and then one COP3 should be done in terms of surrendering a tenancy agreement, and there's different relevant information for both. In terms of managing items, belongings, I will go through this in further detail later on, but the leading case on this is re AC and GC, a case from 2022 in the COP. And in terms of managing finances, relevant information one should be considering is how to manage P's income, what P's financial needs and responsibilities are, how to manage P's savings, how to access money. Those are examples, but are not intended to be an exhaustive list. Moving on to talk about items and belongings, because of course this is a domain that is very often arises in the context of housing cases. So as I've set out, the leading case arguably on items and belongings is re AC and GC. Paragraph 14 of that judgment sets out what relevant information is considered to be relevant when assessing this domain. So you can see here it includes the volume of the belongings, the safe access, is there a creation of a fire risk, safety of building, and removal on disposal of the hazardous levels of belongings. And in this judgment, the court made a variety of best interest orders. They related to house clearing and cleaning services. As I touched on, permission was required for the relevant individuals, whether that be legal representatives, whether that be social workers or agents or staff from the placement, to enter the property in order to clean P's property or to dispose of belongings. The court also made orders in terms of the storage of the belongings and the disposal of hazardous or perishable items. And one key issue I would suggest to remember is that if you obtain, whether that's an interim recital or a final declaration in relation to managing P's items and belongings, including their storage, this arguably permits the court to make those wide-ranging orders that are on this slide. So consequently, I think it's always worth remembering to consider, when you are obtaining capacity evidence in appropriate cases, to make sure that the domain to be assessed is wide-ranging, i.e. to manage the items and belongings, including their storage and disposal, rather than limiting your assessment, for example, to just cleaning, because then that can cause issues later on in terms of the COP's jurisdiction to obtain an order, for example, in relation to disposal of those belongings. I've already touched on here, but it's always worth remembering in the COP that you should use the COP to your advantage. There are many orders in terms of orders that can be granted by the COP, and essentially it is a toolkit that can be used appropriately, providing the COP has the basis to do so. But these are some orders that are further examples of orders that you might want to consider applying for in appropriate cases. So for example, if you have an individual P who's residing in a supported living placement or a care home, and there is continuing problems about their hoarding, you may wish to obtain an order, for example, about managing their belongings and have particular terms. So, for example, that they must exchange or trade old items with a new item. You might wish to consider that the staff have permission to withhold items unless an item is exchanged, and also to protect not only P but also the individuals concerned. It's always worth remembering that detail in orders is key. So you would wish to consider specifically providing for the fact that staff have permission to exercise discretion to discard certain items, and also again back to protecting P, that if a valuable item is found, what are the policies for dealing with it? Will the valuable item stay in P's room, but will it be recorded? And then, as I say, cleaning, permission for staff, that's important when P has a tenancy agreement, to enter the room to clean it. The purpose of the cleaning should be defined. For example, what time staff can enter and what cleaning will the staff be doing in relation to P's room or property. So in terms of some further practical considerations, this quotation is taken from Re AC and GC, and I've included it essentially just to emphasise the importance of the local authorities continuing safeguarding obligations. For example, so even after P has temporarily moved their house so that, for example, it can be decluttered, when P moves back, there are still continuing obligations to support P in maintaining a habitable and safe home environment. So it's always hence the need to consider what orders are required to continue to safeguard P in their best interest. Is an ongoing cleaning order required as part of a final order, for example? When you are seeking orders, whether it's to temporarily move P so that their property can be cleaned and decluttered, always the importance of plans is always, as I'm sure is very well known, extremely important. And when talking about plans, I'm always an avid fan of the phrase more is more, not less is more. And particularly for transition, conveyance, clearance and care plans, that couldn't be more pertinent, I would suggest. So in terms of transition plans, this slide hopefully just sets out some factors that should always be considered. Obviously, they need to be tailored to the applicable case. So, for example, in transition plans, what are the stages of the transition? This includes not only the date of transition, but pre-transition. Will there be familiarisation with it? How will P be informed that they are leaving? So in a case of a hoarder, P is very likely to be attached not only to their belongings, but also to the property. So what considerations will be given to support P in transitioning either for an interim or a final move? What belongings will P bring during their move? Who will assist the transition? What, if any, contingency plans will apply? If there are contingency plans, there needs to be clear provision, not only in the transition plan, but also, I would suggest, in supporting evidence as to when the various contingency plans would be used, i.e. when does plan B or plan C kick in, and if there are any particular proposals in terms of the contingency plan, such as restraint, why best interest evidence should be provided as to why those restrictions are necessary. In terms of conveyance plan, in appropriate cases, it can be helpful to include a separate conveyance plan in addition to the transition plan. As I've just set out, the restraint, if chemical or physical restraint will be used, this needs to be detailed. And in appropriate cases, consideration might be required to obtaining further capacity evidence, for example, in relation to medication, which is dependent on what chemical restraint is being sought. Clear detail on the restrictions that are going to be used on P during their conveyance is really important. This is not only because the court needs to consider and the other side need to carefully consider what those restrictions are, but also relevant to the question of will there be a deprivation of liberty? And as I'm sure again is known, is just because P may not be deprived of their liberty when usually residing in their property, doesn't mean that they won't be subject to a dole during their conveyance. And as any local authority will need to be acutely alive to the fact that they will be the responsible body for that and need to therefore ensure that the relevant authorisations are sought for any deprivation of liberty. Further detail for the conveyance plan could include factors such as the detail of the vehicle, who will be with P, best time of the day to travel, will there be any breaks, and again, clear provision for contingency plans. Clearance plans, if you're seeking an order to clear, clean, declutter P's property, you do need a clearance plan, or at the very least, a schedule of steps that will be used so that the court has sufficient information to authorise an order. So again, considerations could include what the stages of clearance will be, who will be assisting, will there be the involvement of a third party company, in which case permission to disclose relevant documents from the COP will be required, when will P be told, how will the belongings be become known, will a list be done, what is the process of dividing the belongings, what is the process for disposing the belongings, and what will the records, what records will be kept in relation to not only identifying the belongings but also disposing of the belongings. And then care plans, again, the detail is always required. Restrictions for any deprivation of liberty should clearly be listed in the care plans as well. And in terms of particular restrictions in care plans, if contact restrictions or social media restrictions might be applicable in cuckooing cases, for example, then you need to ensure that the relevant MCAs have been obtained. In terms of expert evidence for hoarding cases may very likely be necessary to resolve the issues in the case. Of course, it is case specific, but in terms of the necessity of expert evidence, this could arise, for example, if it needs to be known if P has a hoarding diagnosis or a hoarding disorder. And the remit of the report may therefore need to consider if P has a diagnosable hoarding disorder, whether the hoarding behaviours, for example, are secondary, the impact of behaviour on any other activities, for example, access to the community, and what recommendations does the expert have. The expertise, always, of course, consider the expertise of the relevant experts, given if hoarding is sought to be assessed, it requires particular expertise. And again, if unknown, a starting point could be to look at the relevant authorities that have considered hoarding issues and which experts have been used in those cases. And if it's not clear, email the expert, of course, to confirm if they have suitable expertise and provide a summary of likely issues to be considered. Written questions, always remember the key tool that is provided by Rule 15.7 of the Court of Protection rules, that written questions may be put once without the court's permission, and consider in appropriate cases if the directions need to be varied accordingly to allow time for those questions and a possible addendum report. Section 1.3 and 3.1 of the MTA have been put on this slide just to emphasise the importance of ensuring and reminding the expert that in pursuant to 1.3, all practicable steps must be taken to ensure that P is given the best opportunity to participate in the assessment, because of course with 1.3 a person is not to be treated as unable to make decisions unless those practicable steps have been taken. So in terms of the letter of instruction, it is always helpful, I would suggest, to set out if there is any specific requests that are particular to P that are being sought. In terms of further consideration, I've already touched on this and I'm conscious of time, so I'll take this very briefly, but parallel possession proceedings, always consider if it is helpful to list COP and ongoing housing proceedings. The disclosure, therefore, would become particularly relevant. Seek permission in the COP proceedings to disclose relevant documents and orders from the COP proceedings to the parties in the possession proceedings. And equally, in terms of parallel possession proceedings, there are provisions within the CPR, for example, 5.4c, which allows parties in the housing proceedings to disclose documents. And it may also be worth seeking provision for then onward disclosure by the COP parties if applicable. And again, disclosure may also include permission to disclose relevant documents to any agencies involved in clearing of the property. In terms of the safeguarding obligations, these of course are ongoing, and the LA need to always ensure they comply with their relevant obligations under the Care Act. And this, for example, could include an example of rent arrears, that if P moves on a permanent basis to a care home, the relevant individuals need to be alive to the fact that P may still be accruing rent, and therefore the relevant inquiries need to be made in relation to P's housing benefit, and also consider if P needs an appointee or deputy. So I'm going to pass over now to Peggy, who's going to discuss the complexities.
Thank you, India. As India says, I'm going to be looking at a number of complexities or tricky issues or hot topics, whatever you wish to call them, that I've come across in my practice. I've chosen the 5 I have, and it is 5, albeit there are 6 little circles there. What happened was a template only had 6 circles, and I didn't know how to make it 5 to look good. So I had to divide one category into 2. But 5 tricky issues that perhaps when I went to colleagues in chambers and said, what would you do in this situation? I received shrugs, or I received the answer, there really is no magic answer that I can give you. It's just a practical answer, a unique consideration to this particular case. So the first one I wanted to look at was managing client expectations. And you may be thinking, yes, this is an obvious one. Why have I come to a seminar to listen to be told manage client expectations? However, looking at the questions that we've been asked, and I do encourage you to comment or put queries in the question and answer so we can address them later, and also because it helps to know what other people are doing in response to these 5 separate areas of complexities. So please do put that in the Q&A section. But the very first question that came out was in relation to engagement, and was in relation to what can be done if P doesn't wish to participate in the process. So that just illustrates that these types of cases, hoarding cases, can be very difficult. They can be very lengthy. COP cases in any event can be, but these are the more difficult and the more lengthy ones. The example I've given in the slide is one of the very few hoarding cases that have been reported. It's A, local authority, and X, it was reported last year. And what happened in that case was from 2017 was when they first started dealing with hoarding. It took them 4 years before they issued proceedings. And then the judge in 2 years later said, some 2 years on, despite strenuous and creative attempts by the local authority, by X's legal team, and by the court to bring about any change, the position remains largely the same. So that strikes some fear into any legal representative's hearts, because one doesn't want to be in court 2 years on with no change. But these types of cases do happen. And I mentioned at the beginning because it makes things go smoother if the clients are aware that there are these difficulties ahead. Because of course, as you will know better than I do, our lay clients do have very real difficulties. So for example, there might be an active fire risk in a block of flats that need to be dealt with in relation to the hoard, and they want a solution to that sooner rather than later. But these cases do take some time. Ooh, sorry, wrong computer. The second issue I wanted to raise in relation to managing client expectations was the thinking of practical solutions, that it's a social work practice, not COP legal principles, that will help resolve these cases. And practically what I found is that we have to give consideration to the social worker on the ground. We have to help create for that individual space to deal with these cases so they can produce the evidence that we can put before the judge in order to get the order that we need, whether that's on an interim basis, as India was indicating, or a final basis. So I've given one example there in the second bullet point. I had a case where the individual P, she was very, very distressed when there was any indication of clearing her hoard. So she had suicidal ideation, etc. And so what we did in that case was that we obtained an interim order to remove her from the property. But then what the social worker had to do was to go to the property, to take pictures of the hoard. So she would have 1 week, it would be the living room, she would take pictures. In a fortnight, it would be the kitchen. And the next fortnight, it would be the bathroom, going through the house in that structured fashion. Take the pictures, then she would go and visit P in the care home. They would go through those pictures together, and they would put the individual belongings in one of 3 columns. One was to ditch, was to dispose of. One was to put into storage. One was to keep in the property. And then, of course, once that was done, the social worker then had to actually arrange for the hoard to be cleared, or for the hoard to be stored, or for the hoard to stay in the property. So very intensive work, and it's necessary to assist the social worker to have the space to do that, whether it's by asking counsel to say, look, this is what's needed to be done, please help clear their diaries, or whether it's just a matter of a conversation with a social work manager behind the scenes. The second tricky issue is one of non-engagement with the capacity assessments. And I'm pretty sure all your eyebrows have raised in relation to that. You've had a feeling of resonance in your chests, and it's like, yes, what can I do when P doesn't engage with the capacity assessment? Because of course, one of the manifestations or symptoms of hoarding disorder, or the allied disorders that result in hoarding, are a lack of trust with the local authority, a lack of trust with the community mental health team, lack of trust with any authority, the landlord, if it's a housing association, and so an unwillingness to engage. I am often asked, is there any way we can enforce, is there any way we can force P to engage? And of course, the answer in relation to that is no, you cannot enforce engagement with a capacity assessment. So essentially, the key to the answer to that first question I indicated was made at the beginning is negotiate with them, persuade with them, try again and again and again. And I've said there again 3 times very consciously, because in my experience, 2 times essentially is the minimum, and often try for 3. So you'll have arranged your capacity assessment with the independent consultant, P fails to attend. You set up a second one, they fail to attend. At that stage, review, but often a third one might be useful. This is resource intensive. It also may affect your directions timetable. So you may have to make a COP9 application to court to extend your directions table, but it is necessary in these types of cases to try again and again. The next question I'm often asked is, look, we can't get a face-to-face with P. Can we just do a paper-based assessment? Short answer there is yes, you can do a paper-based assessment, but the long answer is it doesn't really hold much weight. It's really a last resort assessment. Or so for example, I myself have never gone to a final substantive contested capacity hearing on a solely paper-based assessment. And what I found is that generally the process of the court litigation helps generate a feeling of trust with P. So it may be that the judge has visited P or had a video meeting with them. It may be that the process of interacting with their legal representatives has generated a feeling of trust. So as you go on in the in the court proceedings, they become more willing to engage with a face-to-face. So a paper-based assessment may be okay at the beginning to get your interim recital, but as you move along, you should really be working towards having some sort of direct contact with P. And the reason for that is given in the quote at paragraph 2 in the slide. A paper-based assessment is a relatively inadequate substitution for the complex assessments that occur in a clinical interview. So that's the general view of the courts as to paper-based assessments. I've given an example there in the LAA and X case. There was a section 49 report by clinician. That clinician had no direct contact with P. When the judge was going through the capacity assessment, he paid very little weight or very little attention, placed very little weight on that section 49 report because the clinician had not had any direct contact with P. So if that's the case, where resources are limited in local authorities, it really is worth asking, should we go ahead with this unless we can get direct contact? Next question I asked is, okay, Peggy, direct contact it is, but how can we actually get that? So there are different ways of having direct contact with P if you can't get an actual face-to-face assessment. And one is by remote video assessment. Generally, in my experience, I've had these where P perhaps has a comorbid diagnosis of agoraphobia, so they don't want to leave the property, and so the expert has to go to them. It may be in relation to hoarding cases where P, the structural integrity of their flat is so undermined by their long-term hoarding that it's simply unsafe for the expert to go in. Or it may be that the nature of the hoards, we've all dealt with cases where the nature of the hoard includes the keeping of fecal matter, includes the keeping of urine. The expert may choose not to want to have a face-to-face visit at the property with P. So in these types of cases, a remote video assessment may be an option. However, you'll see there from the quotes, the extract from the case of BP in Surrey from 2020, that you do have to make clear exactly what the basis of the assessment is. Was it just video access? Was there also a review of the records? Was there also interviews with others? Because all that holistically makes it a lot more robust of an assessment than it was simply undertaken by video. But video can be used. What else? Telephone calls. Telephone calls were used in the case of local authority A and X. I've forgotten my A in that first paragraph 4. The assessor there, I think he was a consultant psychiatrist, he did use a telephone call to assess P's capacity. However, the caveat there is that he undertook a number of assessments, I think at least 4, but anyway, a number of assessments. And so one of those was a telephone assessment. I think maybe at least one had a face-to-face meeting. One, he was unable, because these took place over a number of years. One, he was unable to see P at all. But when the court was assessing capacity in the round, the telephone aspect of it was simply a discrete aspect. So again, while it is an option and it might be the first thing in the second thing in your toolbox to try, always try and work towards, in my view, a face-to-face assessment. The next one at paragraph 5, the giving P control and help engagement. I found this really, really, really useful. As I indicated earlier, P's in these kinds of situations, a lack of trust with the local authority, a lack of trust with authority. If you can empower them, if you can give them back control or a little bit of control in the process, that does help generate the trust that you need to get them to engage. What we've done in those types of situations is that the parties would agree, let's say 3. There's always a good number, 3 experts that are pre-vetted and that would be appropriate. You obtain their CVs, you give P their CVs, and you say, look, you choose from those 3. In at least one case I've had, the experts have actually agreed to speak with P for 5 minutes, just so he can say, hi, this is my name, how are you, just to get a feel. And in that particular case, he had been non-engaging for a very, very, very long time, but that's control that he got back, that interaction that he had with the three experts, then allowed him to cooperate with the capacity assessment, and we got a robust capacity assessment after that. So that's definitely, it takes a lot of time and effort, but definitely an option worth trying. And then the last tool, and I got the phrase tool from India, so thanks, India. The last tool in your toolbox there, you can use your treating clinician to do it. You may already be doing that via a Section 49 report, but it may not always be in these complex cases that the best person is a third-party expert. It may be the treating clinician who already has a therapeutic relationship, or who already may have seen the individual face-to-faces that can draw on that experience of them to help make their reports more robust. So that's with non-engagement, the capacity assessment. The third tricky issue is assessing capacity to make decisions related to hoarding. Now, I've had a very general title there. You've heard from India correctly exactly how many subsections are needed when you're doing your assessment of capacity in relation to hoarding, but it was a title, and so I needed something short and sweet. The problem here I get is, look, Peggy, P is extremely articulate. She's answering our questions in a really reasonable and rational fashion. We've done our 2-hour assessment. We've determined that she has capacity. She's giving us the answers that we want to hear. But there has been this hoarding problem for the last 3, 4, 5, 6 years, and she is not doing what she says she does. She says that she will. She says she'll give us access, but she doesn't. She says that she will clear, but she doesn't. And there's always a reasonable, or plausible at least, plausible explanation as to why she's not done what she says that she will do. So, Peggy, what do we do here? What I try and say to them, look, the key question is that, is there a mismatch? So is there a mismatch between what P says and what P does? It's very akin to the cases you will have dealt with of cognitive dysfunction, for example, where there's an acquired brain injury, where there's the cases of, you would have heard the phrase of P talks the talk, but she can't walk the walk. She can tell you what she's going to do, but there's a disjunct to actually doing it. So I think the legal way of saying that, or the more clear way of saying that, I set out paragraph 2, that is it clear from their actions that they are unable to carry into effect their intentions expressed in those answers. So that's the kind of scenario you're looking at. My suggestion would be to focus on these 2 main points in your assessment, or to get your assessor to focus on these 2 main points via your letter of guidance or letter of instruction that you're giving to the assessor. So the first is to use clearly documented evidence of that repeated mismatch that has occurred over the years as part of the relevant information. So relevant information that you give to P, the relevant information that you give to your assessor. So clearly document that on 1st of March 2023, we asked her to allow cleaners in. She said she would, but when it happened, she said no. So that, I've said the second bullet point there, draft a detailed chronology to assist the assessor or the judge. So you've set that out in tabular form. So very clearly one can see what one was asked to do, what one agreed to, and what didn't happen. So essentially you're taking a longitudinal approach to the assessment. So the main kind of assessments we see are those short 1-off 2-hour assessments. But here we want to look at the whole contextual history that P has been involved in relation to clearing the whole hoard. So that's one way of doing it. Alternative ways of doing it are undertaking the assessment in stages. By this I mean that the assessor does the first aspect of it. You might be in a situation where there's been an interim order that someone goes in and clears. P has agreed to that, but when it happens, again, doesn't abide by it. And so then you have the second stage of your assessment where you ask her, well, you said this, but you did this. Why is that? And or, as in the case of LA and X that I referred to earlier, you just have repeated assessments over the 3 years. So by the time you get to court in 3 years' time, you perhaps have 4 or 5 assessments. So you can do it that way as well. So that's the first focus. The second focus is what I alluded to, is that is P aware of their deficit? Is P aware that they're saying one thing and doing another thing? Because what has probably come to your mind is that, well, this might just be many examples of unwise decisions. So it might be capacitors, but unwise. So what is the difference? So the difference is really bringing home to P in the assessment to see whether they're able to use and weigh or even understand the fact that there's a mismatch. And the feedback I get from assessors is that when you essentially put it in their face that there is this mismatch, there's a sliding of it. They try to circumvent it. There's a dissociation from that question. And it's that dissociation, that sliding, that's almost ignoring of the question that indicates that this is a lack of capacity as opposed to an unwise decision. So that's, I think, 2 focus points in relation to assessing capacity to make decisions in relation to hoarding. The third tricky issue that I wanted to address, oh no, sorry, that's not. This is 2 examples, 2 quotes from the case of London Borough and A and X that I referred to earlier that just illustrates what I tried to say to you. So in that first quote, we can see that X is unable to use and weigh the relevant information regarding her evidence. And then the 4th line down, the evidence from the local authority establishes that it sets out the repeated attempts by the housing and environmental services over many years to gain access to the flat, which X consistently and persistently thwarted. So there it makes very clear that they want to see those repeated attempts that have been made and then the repeated thwarting of those attempts. And incidentally, this is one reason why hoarding cases in the COP take so long, because when one looks at a less restrictive option of trying to help them P to clear the hoard, it does take time for them to allow them to do it. So you have to allow them to try and fail, try and fail, and try and fail again. And I think my next slide is a similar example in the same case. Over an extended period of time lasting over 5 years, X has been unable, due to the severity of the symptoms of a mental disorder, to use and weigh the information. And then the 4th line down again, the evidential foundation for this rests on the detailed involvement of AB. AB was a support service between May 2022 and March 2023. Their structured, staged, creative and cautious plans demonstrated their flexibility, but X was unable to engage in any meaningful way. So again, they want that detail. And if the court wants that detail in relation to established capacity, as a matter of practice, we have had to put in that type of care and support in the time leading up to a final capacity determination. Moving on to the 4th tricky issue. This was one that I found personally quite difficult. It was dealing with suicidal risk in the courtroom and beyond. And I found it difficult because I was like, essentially, I'm a barrister. Is it for me or for me and my instructing solicitor, or me and my instructing solicitor and my lay clients to hold suicidal risk that's generated by us trying to clear a hoard or to make the property safe? So in this particular case, P had a history of suicidal ideation. She also had a history of actual attempts in relation to trying to clear the hoard, as well as violence to others in relation to trying to clear her hoard, and a comorbid diagnosis of EUPD. So the history of actual attempts and actually violence was relevant to the risk assessment of how credible the threats or the statements that she made to us that she would kill herself and or harm others if an interim order was made to remove her from her home. So where she'd done it before, we assessed the risk as quite high, as being non-professionals or non-mental health professionals. So what could we do? Because essentially we still had to assist her to clear her home because it was in a really poor state indeed. What we did, and it was generally my very, very competent instructing solicitor that took the legwork in this, was we spoke with the court security. So they had 2 security people in the courtroom. We organised a private ambulance to attend court to convey P from the court to the care home. So first we wanted the ambulance in case there was an incident of self-harm at court. Second, we wanted the ambulance as a mechanism to securely convey her straight from the court to the care home. And we wanted it to be straight from the court to the care home because we didn't want there to be any time where in the immediate aftermath of an interim order being made that she was so set against, she had time to harm herself in any way. So we wanted to keep her essentially as under our control as possible in that immediate aftermath. We also organised separate rooms for the ambulance staff. We had one for P, we had one for ourselves. I think we probably used all 4 of the meeting rooms across the road that day. We also had extreme liaison with the community mental health team and the home treatment team. In that borough, they were separate organisations so that they would have a monitoring plan in place with P. I think it was a telephone call and it was a visit perhaps the next day. And then we also liaised with the care home that she was going to be moved to so they could do regular well-being checks overnight and that evening. Luckily, all of that was not needed because in the event, I mean, I'm speculating now, but perhaps a bit of her realised she needed the help. Perhaps a bit of her realised it was inevitable that she would have the help. I think a lot of it was the input from her legal representatives that helped to show her that this was the way forward. But in the event, she agreed to move. And so, although we did use the ambulance, for example, to convey her, none of the measures that we put into place were needed, luckily. But it was a difficult case to deal with, and so that's why I wanted to bring it to your attention. The last one is in relation to where the housing association is landlords. Sometimes I'm asked there, do we need to assess subject matter capacity, or if so, when do we need to do it? So I just wanted to raise, essentially it was a threshold test for assessing capacity, and this applies to local authorities as well. The test there is the 4th line down where I've emboldened it. It's when there is good reason for cause for concern or where there is legitimate doubt as to capacity, then you undertake a capacity assessment. Because of course there's the presumption of capacity. An assessment itself is an intervention that may cause distress. So you need to be sure that or certain that you need to undertake one. And so that is the test that I normally apply. It comes from the Royal Bank of Scotland case. And then the last slide, securing the local corporation, the local authority. Sometimes housing associations have difficulties with this. This is within the context of civil proceedings, so possession proceedings in the county court. I've asked for example, third-party disclosure orders from the social care and the health records. I've had recitals in the county court order inviting the local authority to essentially do what the housing association wished them to do, was undertake a Care Act assessment, provide support plans, set out proposals for alternative accommodation. And then the third and the fourth really depend on the facts of the case. Sometimes the housing association need to vigorously pursue the possession claim to put pressure on the local authority to do something. Sometimes you can invite the local authority to actually make a COP application and stay your possession proceedings. It really depends on the facts of the case. I think that's my last slide. Yes, it is. And Lee, I think it's time for you to step in.
Yes, thank you both. India, thanks for the really helpful overview of all the things that we have to consider in these really difficult cases. And I thought that complexity was underlined by your point about the need to have very specific capacity assessments and not forget about capacity in respect of ongoing management. So I thought that was a really helpful reminder. And Peggy, again, really useful to hear about the complexity and the time-consuming nature of these cases. I think it's a comfort to all of us that that's the reality that everyone faces with these hoarding COP cases, is they are very challenging and they take a long time to pursue. We have got time for questions. We've had quite a few questions coming in during the session, so I'll take us through those. First question, if there are COP proceedings ongoing having been brought by the local authority, but the housing association wants a gas access for a gas inspection, should the application be made to the county court for a gas injunction, or should there be an application within the existing COP proceedings?
I think I would make them within the existing COP proceedings. And the reason for that is that if you went for a gas injunction, you would then have to assess within those proceedings whether P has litigation capacity, for example. If they have litigation capacity, okay, but if they don't, then you then need to find a litigation friend. If there isn't an appropriate person and you're looking at the official solicitor, that all includes delay. You will also need evidence as the capacity is to enter into a gas injunction. All this type of information is already in the COP proceedings, so you would have indication as to whether they had litigation capacity. You may have a capacity assessment that touches on the tenancy type issues of whether they have access to their property. So my gut feeling would be it would be quicker to go to the COP. Do you have anything to add, India?
No, I agree, because otherwise, as you said, Peggy, there's difficulties and further evidence that needs to be sought in the county court. So completely agree.
And I agree as well. I think the complexity of litigation capacity in the county court would make that the unattractive option that going in the COP seems the best for the reasons Peggy said. Another question raised is how to proceed if P's family is strongly opposed to the local authority's involvement. How should that factor in the approach that we take in these cases?
Well, I can start. I mean, obviously the family's views are of course very relevant, and the local authority should, as appropriate, consult with the family, set out the family's views in their evidence, but also invite them or obtain the court's permission for them to be invited, if they're not parties, I'm presuming, but invite them to attend roundtable meetings and give them an opportunity. Provision and directions orders should be given for them to have provision to file statements in response to local authority, position statements, and also attend the hearings. But of course, the family's views is just one component. It doesn't mean in appropriate cases the local authority shouldn't continue to pursue the orders, but it's right to raise their views to the court and to the other side. Peggy or Lee, I don't know if you want to add.
No, I agree with what India says. I mean, my experience is the court process is very civilizing. So press ahead as you have, because your duty is to P. And once you get to the courts, do what India says. And then actually their engagement in the court process makes them, I find, a lot more amenable to local authority intervention.
Thank you both. Another question we have is, if P is assessed as having does the safeguarding duty extend to funding P if they're unable to secure public funding? I'll come to both of you in a moment, but I'll just perhaps share my thoughts on this. I think in a nutshell, it doesn't extend to you having an obligation, or local authorities having an obligation to essentially provide legal funding for P. But the way I would suggest approaching this is firstly to consider whether the court is going or would grant any of the orders you think are necessary to promote P's welfare without P being a party, and that's in theory possible. P can be involved in proceedings through a representative or not being a party at all, but that's probably unlikely if you're asking the court to make coercive orders, access to property and removing properties. So the court will probably want P to be a party, and then you've got the difficulty of them being represented in the funding of that. In a number of cases, local authorities, in my experience, do offer to provide some funding, but that is usually accompanied by some conditions, perhaps exploring the possibility of that being secured, essentially a loan for the representation being secured against the property if the court can consider approving on P's behalf the consent to a charging order on the property, or in some other way raising money. So it might be possible, for example, for a deputy to be appointed to raise equity release that could fund representation. So it's an option to consider just paying over for representation, but I don't think it's an obligation that falls on the local authority to do that. Peggy, Inda, do you have any thoughts on that topic?
No further thoughts, but what I wanted to raise was there was a separate question linked to it, It was where you are the deputy for a client with very limited funds, how do we cover costs of extensive third-party involvement, such as capacity assessments, where you're having difficulty with public services understanding the nuances of the different realms of capacity? And I just wanted to raise that, as that's perhaps an example that Lee was talking about as to where you would want to fund the capacity assessment, because without the capacity assessment, you can go nowhere. And if P has a deputy with very limited funds and can't do it, then unfortunately it might fall in your lap.
Thanks, Peggy. I'm conscious of the time. We've still got lots of questions to try and answer. So we'll move on. The next one, if P's assessed as having eligible needs, can the local authority charge the full cost of clearing or only a contribution? I mean, my thoughts on that would be that if you're providing the service as a Care Act service, then it could only be the assessed contribution that could be charged rather than the full cost. But if it's not part of a Care Act service because they haven't got eligible needs, then in principle you could charge P the full amount.
Yes.
Anything to add or disagree with that?
No, I completely agree.
Great. Another practical question: who should assess capacity regarding a tenancy in a case where the property is owned by the local authority? Who's best placed to do that?
I mean, I would always put, in terms of proportionality and considerations such as time constraints and getting a MCA completed quickly, I would always ask the social worker if they consider they're able to do it, or a member from the social work team. And that's why it's important to provide them with all of the relevant information. So, for example, for tenancy agreement entering and surrendering, you want to be providing the assessor with the relevant information from Islington. But of course, it does depend on the assessor and to make sure that they feel competent. But I've certainly had cases where social workers have completed those domains. Lee, Peggy, please let me know if you disagree or have anything to add.
No, agree.
I agree with that, Solinda. Thank you. Another practical question: if the conveyance plan is going to require some restraint, does that restraint need to be set out in the plan, and to what level of detail?
I mean,
this is a topic you were talking about.
Yeah, no, I'm very happy to take this one. I mean, absolutely it does, because the issue is if you don't set it out and then you go and use restraint, that will be arguably unlawful. The local authority will be at risk in terms of that potential liability. And you want to make sure that any type of restrictions, which crucially involves restraint, is clearly set out in the plans and are authorised. So in terms of a restraint, I know in terms of what restraint can be used, of course, it is a matter for the clients, it's a professional judgment call, but sometimes consideration may need to be given to reform in appropriate cases. This is all subject to instructions, but chemical restraint, does that need to be considered like a form of sedation? And as I said earlier, in appropriate cases, depending on the doses and the type of medication and how it's intended to be applied, you very well might need a separate MCA on P's capacity to consent to medication. You might need relevant information from the prescribing doctor as to why that medication is required, what doses will be given to P, when will it be given, and that all needs to be set out. And then the same considerations for physical restraint as well.
Thanks, India. We've had a follow-up question about the funding of P's representation for those cases where somebody owns their own property but doesn't have cash to pay for representation. How could the local authority secure recovery of the costs of P's representation? Just briefly recapping on that, I think the option, it's difficult, but options in theory, and I've seen it done in at least one case, you can ask the Court of Protection to consider P's capacity to essentially consent to a loan from the local authority, and if they lack capacity, the court can consent on their behalf, and the court can approve on their behalf the condition of the loan, which is a charging order against that a charge be registered against the property, so that the debt is then secured. So that I think is really the only way the local authority can secure its its loan, but of course the recovery of that is dependent on probably on P passing away. So it's not a quick way of returning the money, but I think in practice that's the only way you can secure anything you've lent. Another question raised is about the relationship with the Mental Health Act 1983 and to what extent that should be considered or used in hoarding cases. India and Peggy, I welcome your views. And my experience is that it's relatively unusual for mental health teams to say that hoarding, despite the terribly serious implications for someone's welfare, it's often the case that psychiatrists are saying doesn't meet the criteria for detention. But I don't know what your thoughts are on that.
No, I mean, that's my experience as well. I've not had any cases where it's been considered the Mental Health Act was appropriate. I think in many of these cases, it's difficult to get much input from the community mental health team at all, because what they say is that it requires engagement. It requires someone to have a therapeutic mindset and to want to engage in psychotherapy or community behavioral therapy, and P, by the nature of their hoarding, does not want to do so, and so they can't even give treatment. So it is difficult.
A linked question to that, Peggy, we've had is, what if we think that P is potentially suicidal, but the community mental health team doesn't think that the threshold's met for engagement, and how do you manage risk in that situation? I think that is probably a question for you, Peggy, with your recent experience of a similar case.
Yes, it is difficult. So if you were in court, if you had a directions hearing, you can get a recital and or an order that the community mental health team explain, for example, why they do not consider that the threshold is reached in light of A, B, C, D, and or invite them to lay out possible treatment options. But we all know in practice that it's very, very, very difficult. I think my gut feeling would be we would have to go down the route of something similar like I laid out in the slide earlier, because ultimately the local authority is looking for permission from the court to have an interim order to clear the property. If that's a risk, it's a risk that it has to meet, and so it would have to put in place appropriate measures, as long as it's not jumping over the hurdle into health measures that is precluded from doing under the Care Act.
Great, thank you. I'm conscious of the time, but we've got lots of questions, so we'll take a couple more minutes to try and get through some more. A question we've asked is, how quickly can you get a hearing where there's urgency, and what's the minimum papers to get to the court for urgent cases? I think my experience of this is that certainly at First Avenue House, where a lot of the applications will be issued, there is always an urgent business judge on every day of the week who can gatekeep an application and make orders if necessary list a hearing. So there is always availability of judges to hear matters. The question is whether your application satisfies the judge's view about urgency and the appropriateness of making an order quickly. The real problem for making any substantive orders is usually P's participation. The court will be very reluctant to make any orders without a really clear rationale as to why it needs to be dealt with urgently, a clear rationale for what the proposal is, placement and conveyance plan and all that sort of stuff, and some mechanism for securing P's views, even if that's not full representation by the OS and solicitors and counsel, but perhaps an advocate or somebody who's able to put P's views across in an urgent case. So it's those matters which I think you need to have regard to if you're looking at an urgent case, but certainly the court will always be there and ready to act if there is a case of genuine urgency. I don't know if Peggy and Indy, you've got any other comments on that?
No, only just to add, as you said, Lee, about the difficulties in getting any urgent order without the OS, and if the court have already made, I appreciate me not if you're making that for an urgent order, but if the court have already made initial directions inviting the OS to act and the OS hasn't yet accepted the invitation, then the LA might, in those cases, want to consider funding the OS's attendance for that urgent hearing to alleviate that issue.
No, I'd agree. I think that's more common than ongoing representation funding, isn't it? And that can be sensible to get over an urgent situation. Just a couple more. Views on getting the court to grant permission to withdraw a long-running application where there's no progress being made? This withdrawal, it seems to me, is quite an interesting question as to what the test is on withdrawal. I think some people would say that's a best interest decision. I'm not sure whether that's right. I think it's a case management decision, and so I think you could put a case to say, well, it's all about proportionality, and whether it's appropriate for the court to carry on listing hearings at public expense if there's no way forward, and if the reason why there's no way forward is just because it's a problem that can't be solved, as opposed to because the local authority isn't complying with directions or something. If you're in that territory, asking for permission to withdraw because we've not been doing things right is probably not going to be successful. But if it's a case where, you know, genuinely everyone's done things diligently and tried everything that's been thought of and suggested by the court, but you're getting nowhere, I would have thought an application to withdraw might stand some success. But I should imagine what the court would be looking for in that case is some sort of risk management for the future, some sort of arrangements to ensure there's a bit of a safety net to check that P doesn't rapidly deteriorate from the current situation. But I would have thought that's certainly a viable an argument to run. Peggy and India, any thoughts on that? Any additional points?
I was just thinking the threshold for it would have to be fairly high, that there was nothing more that could be done, because it might be what the local authority went into the proceedings with was wanting to clear the property completely and or get P out of there into more appropriate shelter type accommodation. But actually, this is simply a long-term management, and you may have to get someone in there every 2 months to help clean, and that is the solution. So it might be that local authority needs to change their minds as to what is achievable in the court proceedings.
Yes, I completely agree. And then if so, based on what Peggy said, maybe try and seek within that final order for the proceedings to be withdrawn, but maybe get an order for ongoing cleaning and for the staff to continue to enter if the local authority have changed their approach. Great,
thank you. I think if we might try quickly to deal with two more questions. Peggy, I think this is perhaps one for you. A question about the when assessing capacity and the complexities of executive dysfunction and talking the talk but not walking the walk. The question is whether there's a risk in seeing a mismatch between what people say they're going to do and what they actually do as a sign of incapacity, that actually you might have a situation where P is saying they want to clear the property not because they actually want to do it, but because they know that's what will keep the professionals happy and quiet. And so actually it might not be an example of a mismatch between intention and actuality. It might be something different from that, and P essentially not being truthful. What are your thoughts on the risks of that and how to mitigate it?
I think there certainly is a risk of that, because there would have been likely to have been a long history, and P is likely to have learned that if they say X, then if they say X 3 or 4 times, the local authority goes away and comes back 6 months' time. They say no 3 or 4 times, takes another 6 months. They may have learned that over time. So there is certainly a risk of that. I would say it could be met by, in the letter of instructions or guidance, indicating that that is a concern, and asking the assessor to direct their minds to it. And I think that that's probably a reason as to why in this type of case, a face-to-face assessment is ultimately one of the better things, because it's only through that personal interaction that the assessor can come to any credible view of, is P telling a lie essentially, or do they actually lack capacity and they're avoiding, or they're dissociating away from the question.
Great, thank you. And one final question. It's a question about what status that non-professionals, so friends and families, have within COP proceedings. I think India's touched on this earlier, that actually, and you, Peggy, that actually the proceedings can be very soothing in a sense of relations, and the court will usually be very keen to hear from friends and family as to P's best interest particularly. But I don't know if either of you got some quick comments on that topic.
No, I don't need it. As you said, that they're always welcome, providing the court made it very clear in the orders to present their views, and they always welcome to do so.
I think just to reiterate to friends and family that the COP can be informal in that sense, and they do welcome, in my experience, information and intervention from friends and family, and often do their very utmost, the individual judges, to accommodate friends and family, whether this is something as simple as a technical issue that they can't link onto the Teams and so they have to come in by telephone, or to have a hybrid hearing so they can attend that way, or to have them provide their evidence by way of emails as opposed to COP witness statements. So the COP does do a lot to accommodate and facilitate the interventions from family, friends and family. So be assured of that.
Great. Thank you both. Thanks for those answering those questions, and thanks everybody for your questions. It's really helpful to know what issues people are grappling with and what they want our help with. So thank you. That's going to conclude our session. We've overrun slightly. I'm sorry we've not been able to get to every question. Just a reminder, this has been recorded and you'll be sent a recording of this by email. And another advert for our forthcoming seminars. We've got another on the 15th of November dealing with closed material and contempt and inherent jurisdictions and the Court of Protection. And that's on the 15th of November. And on the 2nd of December, we've got another session on managing fluctuating capacity and restraint in high stakes cases. So you can sign up for both of those on our website. Thanks to India and to Peggy for two very helpful and interesting talks. And thank you to all of you who've joined and listened to this seminar this afternoon. Thank you for joining us. Good afternoon.
Thank you.